lobbyist for the city of Las Vegas, as well as a planning director for the town of Coates, North Carolina. Next, Suzanne Warren. She is the Planning's Business License Compliance Manager at the City of Las Vegas. And she is responsible for ensuring compliance with the city's business license code, which includes the regulation of privileged liquor and medical marijuana licenses. She was also the Deputy Attorney General assigned to the Nevada Department of Taxation and the Nevada State Treasurer, as well as a trial attorney for the Internal Revenue Service. Next, Matt Cyber. I've worked with here at Clark County, and he submits land use applications. And his area of practice focuses on business, gaming, liquor, and privileged licensing, as well as land use and zoning, planning, and building and licensing. He is a graduate from the University of Tulsa College of Law, as well as the University of Laverne with a degree in criminology. And at the end of the table, Jeremy Duke is joining us because he has expertise in eminent domain law. And so he's also a graduate of the Boyd School of Law, like Seth, and he represents numerous landowners affected by condemnations pursuant to Project Neon, and he's also the general counsel for a local medical marijuana company for the past 2 years. So as you can see, a lot of their experience relates to liquor, gaming, medical marijuana, so that's kind of where we're going to focus the conversation. So please join me in welcoming our panel.
Thanks, Jared. I appreciate it, and thank you all for being here this morning. I don't know if it's a good thing that they put us at the end of the conference or a bad thing, but I would encourage all of you, if you're not falling asleep by now, to please ask questions. We want this to be an interactive session. I think that will help us and to understand what you want to hear about, and also help us direct what we want to talk about. I did want to go over a couple of things that I think, and start this discussion with a few things that I think every planner should know. Planners, like lawyers, I think, are to some degree generalists. You have to know a little bit about a lot of things. And to some extent, I guess that makes us what you might call a jack of all trades, but a master of none. But I think that also keeps your job exciting. Attorneys, we have the same issues. We have clients with new and different problems that come to us on a daily and weekly basis, and we have to address them, to adapt and change to address those problems. But there are a few things that I think all of you should know, and I want to start with some of the sources of power for what you guys do, particularly at the local government level. How many of you all are local government planners? All right, most everyone. How about private sector? Okay, we've got a couple of private sector folks. Anybody in something, you just like this stuff? So a few things that all of you should know, whether you're on the private side or the public side. At its most basic level, the authority to do what you do, to regulate the use of land, comes from the U.S. Constitution, specifically the 10th Amendment, and I have it quoted here because I can't quote it from memory. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This is commonly known as the police power that is delegated to the states. In Nevada, that police power manifests itself in the Nevada Constitution in Article 8, Section 8, which provides that the legislature shall provide for cities and towns and restrict their powers. So Nevada is one of a number of states. In fact, most states in the U.S. are what we call Dillon's Rule states. Dillon's Rule refers to a decision that came out by a judge named Judge Dillon in Iowa that basically says that local governments are only allowed to do what they are specifically authorized to do by the state. And in Nevada, that authorization comes from a couple of sources, the Constitution, but then also for most cities, unless you're in a rural area or a very small city, from your city charter. And I have the City of Las Vegas charter here with me. It's a pretty sizable document that dictates what the City of Las Vegas can do. There's a provision in there that allows the city to zone land, which is where most of your authority would come from to do what you folks do at the county and the city. There are also statutes. You all have probably dealt with NRS 278 at some point or another. That's the specific authority to zone at the state level. There are a number of provisions in there that I think are important for you guys, such as master planning land, impact fees, general improvement districts, special improvement districts, and all of those related things you'll find in NRS 278. And by the way, I should mention at this point, this is not intended to be a comprehensive overview of planning laws. There are law professors and attorneys who practice in any one of the areas that touch on what you guys do and spend their entire careers doing it. So, in an hour and a half, I'm not sure we can go over all of that. So this is just a big picture overview for you. And then, of course, there are your local ordinances, the Unified Development Codes that some of you have, or I think in Las Vegas it used to be called Title 19. Now it's the Unified Development Code. I believe all of the charter cities in Nevada have some sort of zoning ordinance, and those contain the specific rules governing land use. So a few other areas that planners deal with on a regular basis. First of all, property rights, and Jeremy is going to talk a little bit about eminent domain and inverse condemnation. There was actually a case that came out about 2 months ago that sort of sets Nevada's rules on inverse condemnation. It came out of Washoe County. So Jeremy, I think, is going to talk a little bit about that. If not, I've got some notes here. We can go over that, because it's not very often that in planning there is a brand new hot button case, because these cases don't come about that often, particularly from our Supreme Court. So it's kind of interesting that we have a case that came out not long before your conference today. Open meeting laws. If you deal with planning commission, you have to know about open meeting laws and notification requirements for planning commission. That's something that usually is kind of built into your notification scheme. It's not something you think about on a regular basis, but as attorneys, one of the first things we look at, and when there's a challenge, is was this properly noticed? So that's something that becomes very important when you get to a court. Let's see, impact fees. There are some interesting U.S. Supreme Court cases on conditions of approval, exactions, impact fees. You may have heard of these before. We usually call it the Nolan-Dolan cases. Basically what those cases say is that if you're going to have a required dedication of land or some other condition of development, there has to be a nexus with the development itself. So for example, you can't require a property owner who owns land in one location in the city to dedicate an easement on land in another part of the city if that's not related to the development application they're actually applying for. There's a fairly new case called Coons versus St. Johns River that actually extended that to requiring monetary payments. In that particular case, there was a developer who wanted to build on what was designated as a wetland area, and the local flood control district there in Florida made them pay, I think it was $150,000 to create another wetland area somewhere else. And the U.S. Supreme Court said that was going too far. That was an improper impact fee and an improper condition on development. So you have to be on the lookout for those things when you're working with developers, particularly on big projects. One thing that I know is common here in Southern Nevada, because I dealt with it when I was a planner at the city of Las Vegas, is when somebody comes in to develop a large subdivision and there are specific on-site and off-site improvements that are required, there has to be a nexus to the development itself. So for example, RTC may require a bus stop. You may have to finish out the entire street that's just outside of the development. You may have to extend or expand water and sewer lines, those sorts of things. Obviously, there's a nexus there, but you always want to be on the lookout for those when you're approving these projects. Freedom of speech and First Amendment issues. While I don't think you necessarily need to be experts on First Amendment law, like I said, there are law professors who devote their entire careers to this. There are, particularly in Las Vegas, Fremont Street. If you've ever dealt with anything on Fremont Street, there are a couple of Ninth Circuit opinions that actually deal with whether Fremont Street is a public forum and how you can regulate certain uses and certain speech on Fremont Street. So I think those things actually come up for you guys from time to time. There was an interesting case last year out of the U.S. Supreme Court. Any of you who deal with signage have probably read this case, Reed versus Town of Gilbert. This case came out of Arizona, and basically what the city was regulating was directional signs. So in this case, there was a church that rented a space in a shopping center, and they posted, I think it was like 17 or 18 directional signs to guide patrons to the church. And the city had very strict regulations on directional signs. What was interesting about this case was that the ordinance actually only restricted the size, number, duration, and location of the signs, but the court held that this was a content-based restriction because it only applied to those directional signs. And I think there was, if I'm reading between the lines, there was probably also a sort of a selective enforcement of these signs because the city didn't appreciate the use. But what this has caused is sort of a ripple effect for a lot of jurisdictions to go back and review their sign ordinances and make sure that they are complying with the new rule that came out in Reed versus Town of Gilbert. If you were going to Google one of these cases and read about it, I think that's one of the more interesting ones, particularly that's come out recently. And then another thing I wanted to point out before we get to the panel, one thing that's very important from an attorney's perspective that you may not think about once your item that you're working on or your development gets to Planning Commission or City Council is making a record. What's very clear in Nevada jurisprudence is that the board or agency or Planning Commission, City Council that's making a decision on an application, whether it's a variance, a special use permit, a vacation, any other application that they are approving, it's critical that they make findings of fact, that they make a record as to why they're making the decision that they're making. Because typically, the only way something gets overturned when it gets to court, and by the way, if it gets to court, somebody's done something wrong, because these don't get to court very often because they're discretionary acts by the board. But they get overturned when there's no evidence to support the decision. And that's kind of pretty consistent. There are a number of cases where the problem is not the decision that was made, but that the Planning Commission didn't really make any findings of fact. So I would encourage any of you who provide support to Planning Commission or City Council, and the attorney monitoring this shouldn't be asleep at the switch. They need to make sure that there are findings of fact that are being made to support the decision, and typically those discretionary acts are going to be upheld. There are a couple of exceptions. When I was a city planner, I always thought if anyone ever challenged a variance, 90% of the variances that we approved in the city of Las Vegas would be overturned, because I was never real clear on how they were defining a hardship, such that a variance was required. But those don't get challenged very often. I think there's only one case in Nevada actually that deals directly with the approval of a variance, and most of the time that's because there's really no opposition to it, because everybody wants whatever the developer is proposing. But I always wondered how that would play out if people started challenging these variances. But anyway, with that, I wanted to turn it over to the panel. And by the way, please ask questions again. I think that will help us to decide. I think we'll start with Jeremy on the end here. I didn't really touch too much on eminent domain because I think Jeremy's going to cover that. That's his area of expertise. He in particular, and the reason why I asked him to be on this panel is his law firm has dealt with a lot of issues surrounding Project Neon, which, as we all know, is a long-term project going on that's going to affect the 15 for about a 3-mile stretch. And it affects me personally because my office is on the wrong side of the 15 trying to get to court. So I'm hoping Jeremy's going to tell me it won't be so bad. But anyway, let me turn it over to Jeremy.
Thanks, Ed. So I kind of wanted to just start with a general overview about how eminent domain law works in the state of Nevada, and I'll talk a little bit more about the Ad America case, which Seth touched on earlier, that dealt with Project Neon and inverse condemnation takings. But I kind of want to give you guys a little bit of a background just so you understand the terminology that I'm going to be using, so that it's not just lost on you, because it can be a little bit complicated, but I think I can get it down to a manageable size so we can get your arms around it. So the first part about this is Seth had noted that of how the powers of eminent domain are applied to the city, state, municipalities. The power that landowners utilize in order to protect themselves from takings comes from the United States Constitution under the Fifth Amendment, that no property shall be taken without compensation being provided. But it's also applied in our Nevada Constitution as well, which the Nevada Constitution actually expands upon that and says that no property be taken without just compensation having been first provided to the landowner. So it's a little bit of an expansion. It's semantics to a point, but it does allow landowners to pull out money, for example, if their property is being taken before the end of the trial, which a lot of times is very helpful to them if they're utilizing it to move to another property. The other portion of the law that really focuses on this is Nevada Revised Statutes, Chapter 37. And that chapter specifically covers everything under the world eminent domain. So if you ever have a question about eminent domain law in general, that's generally the place to first start looking, as that will cover the majority of the interest here. So I'm kind of just going to give you guys a general overview, once again, about the different kinds of takings that we have. The highest level ones, which are the more difficult to prove if you don't have the evidence in front of you, but if you have it, it's usually pretty plain and simple. There's that direct regulatory taking, and there's two kinds of those. There's one that's just a permanent physical invasion of land. There's a classic case, Loretto, which is essentially saying that even taking a small cable cord, for example, on an apartment building, and putting it into the wall because that's required by the city, that's a physical invasion of your property, that's a taking. It may be a minor taking that doesn't acquire much value to you, but it still is a taking. Then you go to regulatory takings that completely deprive the landowner of all economic interest in the property. That's a little bit more difficult to prove because you have to basically show that your property is 100% useless at that point. It does happen sometimes. I haven't seen very many of them lately though, just because you can always do something with your property generally. Then we go down to there, and Seth talked about this earlier, about the Nolan Dolan exactions. Those are also rare circumstances where there's some sort of a requirement that the government puts on a land use permit, for example, that's not related, or doesn't have a rational nexus to what the action necessarily is. Where we get into a little bit of the more unique fields is Penn Central takings, which are regulatory style takings that are not really based upon a specific regulation itself. So courts look at a little bit more broad factors in those situations, like what the regulation does to the land, how it affects the landowner, that it doesn't necessarily deprive them of all economically beneficial use, but still some use to that property. Their interference with investment-backed expectations, which I'm going to come back to that because I think that's really important to understanding how eminent domain law works. And then we talk about how the character of the government's actions, whether it unfairly signals out the landowner, and there's several other substantial factors that go into there, whether or not the municipalities reach a final decision on the action or with regard to the property itself that's being affected. Necessarily as well, whether or not the landowner even needs to avail themselves to certain administrative remedies, such as appealing a decision on a land use permit. Sometimes it's obvious that would be futile, and sometimes in those situations the court will say you don't have to go back and actually appeal a land use permit that was denied. So what I wanted to say about the investment-backed expectations, one of the things about eminent domain law is that whenever you look at a property, you don't just look at it as an appraiser from what its current use is. You look at what its highest and best use is. And the best example I can provide for that is one of the cases that we've done in my firm a couple years ago. It was a very small taking, probably about 550 square feet, somewhere in that range. But the gentleman who owned the land had plans to actually put a high-rise condominium complex on the property. He had plans for it, he'd gone through the land use permitting process and was permitted to do it, but this exaction that was taken out of the land for a widening utility use along the roadway frustrated his ability to make the property profitable for himself. So he could still build it, but under the current setup, it shaved off a substantial portion of the front of the property. So now his luxury condominium complex was no longer able to be profitable in the future because so many units were taken on. And that's a situation where the initial offer was merely the taking of the land, which was somewhere in the range of $150,000. We were able to acquire over $20 million for our landowner in that sense, because that's what the highest and best use of the property was at that time. And that's what's going to come into play for you guys, I think, more than anything else, looking at what you do to plan and how that affects property owners in the future. So I want to touch on, as Seth pointed out, the America case, which my firm has represented in the Supreme Court, and a decision recently came back on that. The uniqueness about that case is that it helped clarify for Nevada what an inverse condemnation taking is. An inverse condemnation taking is when the landowner says, government, you should have taken my property a while ago and you didn't, so now I have to bring this action against you to force you to take it from me, because you should have done it and now I have to do it. That's a very specific and high burden to meet. And those cases those situations that I laid out for you, such as a Penn Central taking, those are more unique and have those nuances built into it. But what our state Supreme Court here said was, it's a very extreme case that you have to prove in order to reach an inverse condemnation taking, which says that they have to have government regulation, or potentially no regulation at issue, just government actions that are pursuant to a large form regulation that maybe doesn't necessarily affect the land, such as Project Neon. Project Neon has come out with maps identifying properties since 2007. We've gone through several versions of it. We have a final environmental impact statement, a record decision, a reevaluation of the environmental impact statement in October 2010. You've got an MLK flyover that was there in the initial part of the project, now it's gone, and which necessitated the reevaluation under NEPA requirements. There's been so many versions of that have come out. Sometimes when you have those situations where a landowner's property is taken under every single circumstance, you can say that, yes, government, under those circumstances, you should have taken my property a long time ago. That presents a lot of difficulty when you have projects that are 20 years or more. Under these circumstances, though, as I said, is you have to look at some sort of regulation, or perhaps something like Project Neon, just a project that maybe doesn't directly affect the landowner. Then we look at whether the government has taken steps to directly and substantially interfere with the landowner's property rights. And that's something to do with whether that be denying them a land use permit. If they wanted to build on their property, but Project Neon now made it so they can't build on their property. That could be blighting an area by buying properties around the area, but not purchasing this landowner's property, which drives down the value of this landowner. And then later on, the federal government comes in, or excuse me, the state government comes in and files an eminent domain action. And that sets the date of valuation, which is very important. So in that circumstance, let's say the government bought a bunch of land in 2013, demolished it, left this landowner, and now in this year, 2016, comes in and would like to purchase the landowner's property for under eminent domain. That's driven down the value substantially now that the area is blighted, because the actual date of value is 2016. In an inverse condemnation action, as I've been discussing here, the landowner says you actually took it back in 2013, and under those circumstances, and again, that loosely applies to facts. But that's the situation that applies, because then you're going to garner a higher value, and you say to the government, you've degraded the value of my property, and I should have been getting it at this value back in 2013. So under those circumstances, the state Supreme Court also further clarified that it's a very unique set of circumstances. You have to prove a damage to the property. Now, while that raised the bar generally for what's required for an inverse condemnation taking, there is this second form of taking which doesn't actually lead to a taking, it just leads to pre-condemnation damages. And that's something that hasn't really been touched on by the Nevada Supreme Court in a while. In fact, they specifically in the Ad-America decision said we're not going to address that, only because our client in that case still had a pre-condemnation damages claim outstanding. Now, pre-condemnation damages is a little bit similar to that, but the difference, is that the landowner gets to keep their property at the end of this circumstance. So let's say the government has, for example, I'll say Project Neon just because it's the easiest representation that we can provide here. As I said, you've had maps coming out since 2007, you've had public meetings, you've had letters to go to the landowner saying your property needs to be appraised, that we need to do soil boring on your property, that your tenants may need to be moved off to a new property, which is another bag of interest when you talk about getting involved with tenants and moving them to other properties and making sure that they qualify under the URA, but I won't touch on that for now. The point is that the government comes in and says, we've done all these actions, and the landowner says, you've done all these actions and you haven't taken my property, but you've more or less announced, based upon these series of events, that you're going to take my property. And then you didn't. And that's the second step, is to show that there's been some oppressive conduct or a substantial delay in the action that led to that not being a taking. Under those circumstances, as an example I said earlier, blighting an area, purchasing a bunch of properties in the area, and then the area becomes blighted, your tenants get drawn off the property because they no longer want to be there because of vagrancy, and property values in general get drawn down. Now at the end of this you say, okay, you announced that you were going to acquire my property, but you didn't. You did something that damaged my property, and now here's my damages at the end. Now this is where it gets interesting, because this says that the landowner can acquire their difference in fair market value from the current date, whenever they file their suit, back into the date of whenever the government actions announce an intent to condemn. Now under these circumstances, let's say you drove down a property from $1 million and now the current fair market value, because the area is blighted, is now $500,000. That means that you can acquire $500,000 from the municipal entity that's doing the project, or the state entity that's doing the project, and still keep their property, because the property hasn't actually been taken. It's just the actions of the government have pre-condemned the property in order to drive it down. And this is something I think is very important for planners in general, just because this is a factual specific determination that's made by the court. And under these circumstances, you can have a project that requires you to take a property, but you don't, and you do a lot of things that show a taking of the property is inevitable and going to come. And then at the end of the road, when the landowner brings this pre-condemnation damages action, now you have to pay them for the difference in what their original fair market value is to now what their diminished fair market value is. And then what happens when you have to acquire the property later on for the project anyway. And I think that's something to really pay attention to when we talk about these circumstances and pre-condemnation damages. They're factual specific arguments. Inverse condemnation takings, as I said, as applied by our state court in Ad-America, is a little bit more difficult to reach for landowners. So it'll be a little bit more difficult for a landowner to say that you should have taken my property, so now I'm going to force you to take it. But under those circumstances, as I said, there's a higher burden, whereas pre-condemnation damage is a little bit of a lower burden. I think there's a lot more options for liability that can go out to municipalities, and that's what I would be a little bit more concerned about. As Seth pointed out, planning is very important, and showing all this information is required by NEPA for the federal government in order to get funding. One of the things the Supreme Court said in Ad-America was that when federal funding becomes an actual reality. Not necessarily when it's provided to the state, but when you've done everything you need to do in order to reach federal funding, i.e. file your EIS, get your record of decision, now you're ready to accept federal funding. That's when you start to talk about things coming to a head. And that's when you start to talk about when a pre-combination damages case, for example, can be applied. So timelines are very important in making sure you don't run past that. Project Neon, I know, as I said, has gone through numerous different versions of it. It was initially not funded, then it became funded, then it became a public-private partnership, and now it's a design-build project. This is an extremely long-term project that was supposed to be brought out over 30 years, over 5 phases when it first started. Now we're talking about 4 phases over the course of about 3 or 4 years. Maybe some back-end stuff with regard to utilities and the like at the end. But it's important just to, as I said, to note that planning is important here, but also making sure that you have a tight timeline that you're applying to when you're putting out this information, because landowners are aware that they have rights, and something that's lost a lot of times in the disconnect between the federal government, state governments, and landowners is that landowners now, for example, have sat on their properties under Project Neon for almost a decade now, and have been showed maps saying, hey, we're going to take your property at some point for this road project. And no one ever doubts that this road project for Project Neon is a good thing, because it's going to be great. It's going to expand a lot of these freeways, we're going to have HOV lanes, we're going to have more access points. It's generally a good thing for the state, but these landowners now, they can't do anything with their property. You ask yourself, put yourself in the landowner situation and ask yourself, would I develop my property if I knew it was going to be taken? Am I sure that I would be compensated for that, or would the government say, well, you should have known better because this project was coming through and you developed your property anyway, so we're not going to enforce this because you didn't mitigate your own damages. It's a very sticky situation for landowners to be in, and that's generally where we try to step in and try to help them out to untangle that for them. But that's kind of a general overview about where planning law is for eminent domain purposes. So I don't want to belabor the point too much.
So if you're wondering why these projects are so expensive and take so long, it's Jeremy's fault. Sorry, guys. No, I'm just kidding. Jeremy, does anyone have any questions for Jeremy? Yes, ma'am.
I have experienced the process of land acquisition for, in this case, Southern Nevada Water Authority, when they put the distribution system around the valley. And in one case, I had a property owner who he was zoned for commercial, and we needed the first 50 feet, I guess, off the front of his property. And he said, well, you need to pay me more because you're taking my frontage. And I said to him, yes, but I'm creating a new frontage for you, so I should only have to pay the value of the land except for the frontage. And I got away with it. Was that the right thing to do?
That's another area that's a little bit nebulous. When you talk about damaging a property, there is certain rights that you have, abutting land, you have rights to frontage and the like, and sometimes your property is damaged under those circumstances. As you said, that's kind of the quarry between the landowner and the agency is, you're taking my frontage, and as you said, but I'm creating new frontage for you. I hate to say it, but it's sadly the point that a lot of money is spent on these kinds of cases. And I got to tell you, the eminent domain law is run by appraisers. They have a lot of value there because in that situation, I'm sure I'm not sure actually, but under those circumstances, many times you would have an appraiser to come in and say, you know, here's how much the taking of the property is. It's usually what's required whenever you guys get involved in a taking. And then you look at the frontage and say, well, there's no damage to your frontage because I'm not taking it, I'm creating new frontage. And then the landowner comes in and says, well, I think you are damaging my frontage for this and this and this reasons. I don't think it's necessarily a cut and dry one way or the other. I think it becomes an issue of whether there is an obvious damage to the property at the end. I don't think you went about it wrongly though. And I don't think you, like, quote unquote, got away with anything. You were doing what was your best interest for the water authority. And I don't think that was necessarily a bad thing. Nor was it necessarily the wrong decision if they went with your choice that there was going to be more frontage involved for the landowner. There's a lot of other cases we've dealt with in other parts of the valley where transmission lines need to be relocated from one property to another. In those circumstances, once again, the planning is a little bit more tight, so there's a lot less information put out to the public as to what's going to occur. So pre-condemnation damages are a little bit more difficult to prove in those kinds of situations. But in those as well, there is existential factors that are built into valuing a property that's being taken for, power line I think is a good example, only because now you have something located on your property that's going to take a certain amount of money. And you also have the fact that it's creating a height issue with if you want to build anything upon your property. Now you have this massive power pole on there. Can you build your property with anything on it? That goes into the highest and best uses I discussed earlier. You need to have something planned. If you have a house on your property, let's say it's a duplex, and somebody comes in, the power authority comes in and says, we need to relocate a power line on here. You can't simply say, well, I can't build an office building on here now, so you have to pay me for an office building. It has to be reasonably probable under the circumstances. In those kinds of situations as well, when we talk about those types of easements, we look at what the gravity of the easement is. So the power company, usually in their easements when they come in, they'll say, well, we can build a transmission line here, but we could also build this, or this, or this, or this, and 5 other different things. And the key part about that is the intensity of that easement also will help determine the value that is provided to the landowner in those situations. Most eminent domain actions, unfortunately, are built upon facts. We have another landowner that has to deal with a flow issue where the state, the water authority forced him to put a culvert into his property, and then later didn't increase the flow essentially without telling him that he was going to do so. So you have an interest in the amount of cubic feet per second of water that's flowing over and under your property. So there's a lot of aspects that are built into that. I don't think there's as much that can be done for pre-condemnation damages in those situations. There is something to be said for the highest and best use and how much damage it actually does to the property, which is once again where appraisers come in. And I can't stress enough that it's really important to have that, because it's very difficult for a landowner to quantify what's being taken from them, what's being applied to them, if they don't have something to look at. If it's just a number out in the ether, it's very difficult for them to say, well, that might be what my property's worth, that might be what the amount of damage that's being done. And unfortunately, in a lot of these situations, it necessitates both sides paying an appraiser before you can come even to a negotiated solution. But that does happen, it is routine, and it's never going to be an issue, I will tell you, under very, 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 very slim circumstances will you ever run into a problem where the Nevada Power Authority comes in and wants to, or NV Energy wants to come in and take a area of land for a power line, and you can say that, well, that's not a public use and you can't take my property. I can assure almost everyone here that if you guys have a project and it's a public use is very, very broadly drawn. And it's pretty much anything under the sun outside of transferring it to a private party. So you will always get the project done. It just becomes an issue of how much you may have to pay the landowner to do it.
Yes, sir.
So I may have missed it, but initially, if you negotiate for compensation, do you consider the assessed value, market value, or whoever, it depends on how you litigate it or something?
There's a couple different ways to go about that. As I said, we always look at the highest and best use of the property, which is the most intensive and best use of the property that's reasonably probable at the time. Most appraisers will go through an exercise where they'll value it under several different setups. Usually it's an income-based setup, where if you have tenants on the property, you look at how much that property is drawing in income-wise per year compared to other properties that are drawing income with tenants, and eventually value it out based upon whatever the date of valuation is. The other side of it is the sales comparison approach, where we look at just other sales in the area around that same time period of properties that are reasonably similar to what your property is that's being condemned, and then come out with an average usually on that. And we'll take into account severance damages, for example, if you're only taking half of a property, for example, there's value to having an entire acre of land. And if you take half of an acre and leave the landowner with only half an acre left, now they have this property that's not as easily developable, that is perhaps not suited for certain uses because of its size now. Now that severance from the main parcel is valued as well. So we take into account that interest that's applied into their temporary construction easements, also have a value attached to them whenever the government's doing something. So that's also applied into an appraiser's valuation. But we usually apply multiples, and then the appraiser will average out based upon the different versions of how you can value the property as to which one is the best option, and try to get a fair number to get the market value of what the property is.
And at the end of the day, when you say just compensation, will that be because the Now, whether the property is happy about the compensation, or it would be like a two-way street.
Well, happiness is certainly subjective in anything, and I definitely say when it comes to negotiating to have your property paid for when you didn't want to take it in the first place, happiness is even more subjective. I'd say just compensation, the literal term is putting the landowner back in the position he would have been but for the taking of the property. So that's attempted to be quantified through the appraisal, because that's why we're looking at the highest and best use. If you had never had the property taken, you would have built, a condo on it. If you had never the property taken, you would have had a full acre to develop on. There's all that takes into account to get at the end your just compensation, which supposedly puts the landowner back in the same position they would be. One of the tenets of law is that land is unique. And so that's why under most circumstances, you're never going to find a situation where the government says, well, instead of paying you just compensation, let's just swap out some land that's on the other side of the valley. It's a barren acre. You don't have anything on your acre, and it's zoned the same, so that should be equal, right? No, obviously that's not the case. Land is unique. So under those circumstances, just compensation really means whatever the value of the property is to put the landowner back in the position that they would have been but for the taking.
But I'm pretty sure Jeremy's client, who was offered $1 million and got $20 million, was pretty happy.
Yeah, he was all right.
Question over here. So I'm curious, you talked about the timeline, and specifically, I guess, for planners, where should we be concerned about where our risk increases in getting involved in some of these preeminent domain issues? And specifically, I guess I'm thinking, is there a benchmark in the overall, say, project timeline where, we need to start with, say, a visioning process at the very beginning, and it may present several alternatives, and if one of those alternatives, has effects on certain properties, where along the project timeline is that benchmark? Is the NEPA process, what do we need to be concerned about as far as presenting these plans?
Sure. A lot of this is focused on what the Nevada Supreme Court has pointed out, is they have an interest in whenever you have the, not necessarily when you acquire funding for a project, but when the reality to be able to acquire funding comes to fruition. That goes into the NEPA process, as I said. So the Supreme Court in this has limited its determination to events that occurred up until December 2012. So what they said essentially is that no, we don't think that there was an inverse condemnation taking under these circumstances, but if you have other facts that occurred during that timeline or that occurred after 2012, then come back to us, maybe you do have taking. I think the key though there, as you said, is when you start looking at if you need federal funding and you have to go through an EIS, or you've done whatever is required in order to acquire funding for a project, not necessarily gaining the funding, but reaching that level that you've done everything that you can do is usually a good trigger point. I don't want to tell you definitively that it is, only because pre-combination damages are very factually driven. They're based upon what's sent to the landowner, what's published to outside of public meetings and in public meetings, whether they've spoken to city planners or state planners on something. I'd say the general good rule of thumb is to keep your timelines relatively tight. You do have to obviously produce a lot of this stuff to the public in order to make sure you're planning it correctly and making sure all the interest holders that are involved are actually getting their rights vindicated. But I would say the longer that you plan something out, the more likely you are, and the more that's delayed, the more likely you're going to run into situations where landowners are going to request more compensation than potentially what they could have been before. I would generally say that having that interest in a long-term project is very important and needs to be done, especially for something that's billions of dollars like Project Neon is right now. But you want to make sure as well that you're providing information to the public that's realistic. I know a big contention point obviously was that MLK flyover on Project Neon, because it was something that had to be brought back to the federal government in order to change that. So I think when you come out with something, knowing not only the direction you're headed, but having a more solid foundation about where you're headed is very important. Internal planning, I think, and throwing ideas around is a good thing, but if you can get as close to concrete as possible when you start revealing the things to the public, I think that's ideal, and that protects you more than anything else, because then that's as close to the final plans as you're going to get, and it's less likely that you're going to take an extended period of time in order to reach the final decision on it. I hope that answered your question. That was a little bit broad.
And while I'm not an expert in this area, there are a couple of Nevada Supreme Court opinions that, while there's no case that's going to give you an exact date in every case, but there are a couple of cases, including one that just came out in August, Washoe County versus, I think it's Fritz is the party name. that refers to an earlier case that basically says, at least for inverse condemnation purposes, mere planning, I think that's the quote, mere planning alone is not going to be sufficient to constitute a taking. Now, what mere planning is and what goes beyond mere planning, I don't know that they defined it that well. I'll tell you the Washoe and Frisk case, what happened was there was a property owner at the bottom of a hill who was affected by the approval of a final map and some other development approvals up the hill that affected water flow into a creek that ran through the property and caused the subsequent development of that property caused some flooding. And the court determined that there could be liability for inverse condemnation. Again, they weren't real specific on when that trigger happened, but certainly at some point in the planning process, you might be causing damage to someone's property for which Jeremy's going to come and get it. Just kidding, he's a nice guy. I actually had one question, if there are no other questions from the audience. For those of you who've been around for a while, and you remember the Pistol Initiative, People's Initiative to Stop the Taking of Our Land, I think is what that stood for. That came out, that legislation was proposed after the Kelo decision, which I think all planners are, just like Village of Euclid, it's one of those seminal cases that you all learn about in planning school. But Kelo basically said, and Jeremy touched on this without naming the case, Kelo said basically that, Kelo said that a public use is almost anything, and a public purpose is almost anything, including giving land to a private developer to develop a blighted area. In response to that case, which was very unpopular in a lot of states, including Nevada, there was a constitutional amendment that actually restricted that to some extent so that it defined what a public purpose was with a little more clarity. One other side effect that, at least when I was lobbying for the city of Las Vegas, was of concern to planners, but I don't know that it got a lot of press, was in Section 22 of Article 1 of the Constitution, there was an amendment that states that property taken in eminent domain will revert back to the original property owner upon repayment of the original purchase price if it's not used within 5 years of the original purpose stated in the owner. We were concerned at the time that particularly for long-term projects like Project Neon, it would make it impossible to plan for a project like that because you're going to have all this property reverting back. I don't think that worst case scenario has happened, but Jeremy, I was wondering if you have any experience with cases where property owners are asking for their property back because the city hasn't used it within the 5-year window.
Yeah, I mean, I personally have not heard of any specific situations where that occurred. I know that that was certainly an issue, and that's something that the Supreme Court brought up in America as well, is that, if you're ever worried about your property being taken too early, just you want them back if they're not used within 5 years. The nebulous aspect of that is, what is the use? Does it have to be completely developed upon, based upon whatever the construction plans were for the property? Does construction just have to begin by that time period? I'd venture to say that the Supreme Court, or any court, would say as long as you're making some sort of construction progress on the property, that you would be within your rights to continue holding that property without having to focus on the 5-year rule. The other issue is that, as you said, the landowner would probably be the one that has to actually bring a case against them to say, which means that they'd have to have the property taken and then be essentially being a hawk on the property to make sure that some construction is being done on the property. So I haven't seen anybody do that, just because most people, they get their money and they're happy and they go about their business and buy a new property or go invest it somewhere else.
Yes, sir.
One example would be the RTC and the South Strip Transfer Terminal, where the L-shaped parcel and the transfer terminal itself was built and a parking lot was built, but there was still some land on the north end fronting on Sunset. And the former landowner threatened to demand that it be settled back to him at the selling price unless something was done. So within 6 months, the northern end became a parking lot.
So he was paying attention and asked for something to be done. Yeah, that's interesting.
And he got our attention.
Well, I mean, that's kind of unfortunately the situation that occurs. And a lot of times, I've seen a little bit more common lately is that if you're purchasing an entire property and the state determines under their current plans that they may not need it and they'll have a remainder, a lot of times they are willing to sell it back to the landowner just to make sure that situations like that don't occur. And they're not just holding land, which it doesn't really benefit anybody in the long term ultimately if the state's just holding land, and that means that's more funds that are just tied up in land that could be used to a different project, especially when they could be instead held by a landowner that might maximize it for something else. but it's nice to know that somebody out there paying attention.
And one thing that we haven't really touched on here is, to some extent, particularly folks in the local government planning departments, you have political concerns you have to think about too. I mean, that's the overlay on all of this, right? Like, you're not entirely autonomous in what you do. You're being directed to some extent to do things by your elected officials, and that's something that, and I can assure you, they are not paying attention to the court cases and what's going on, because that's not really at the forefront of their agenda usually. So that's another thing that I think makes your job challenging when you're planning projects, particularly long-term ones, is, you know, you come up with what you and your colleagues in the city agree is a great plan, and then a councilman has spoken with the developer because he went to college with his wife, and now all of a sudden everything has changed. I actually haven't had that specific happen. I'm not talking about it. I've seen similar things happen. So thanks, Jeremy. We've got about, good, plenty of time left. I wanted to turn it over now to Matt and Suzanne. As Jared mentioned, they are going to discuss a couple of facets of what I would call vice industries. I was about to say they're experts in vice, but that might. What I think is particularly interesting, and I've worked with Suzanne directly before, is that Suzanne has a legal background and is now serving, handling business license compliance for the city of Las Vegas, which I think gives her a unique perspective on kind of the legal side and then actually implementing that on the ground, which are two totally different disciplines. So I think I'll turn it over to Suzanne, and if you have any questions, obviously pipe in at any point.
So Seth mentioned that lawyers and planners, we tend to be generalists, and I decided that after close to 10 years doing tax litigation that I was too specialist, so I decided to become a generalist, and I joined the city of Las Vegas. And I'm not an attorney for the city, so it is an interesting role for me because I am an attorney, but yet I'm not an attorney in my day-to-day life. I'm a manager, and I manage the license officers in the city who inspect businesses for compliance with the city code. They are in liquor establishments, medical marijuana establishments, massage establishments, sexually oriented businesses. So all of the sort of vice industries that, you know, we'd like to discuss a little bit today. You know, sometimes I talk to my license officers about how naive I've been, because my whole practice up to this point has been, you know, in tax and finance and looking at numbers, and now all of a sudden I'm in the street and I'm seeing, wow, there's a lot of things going on. Sort of my expertise, I guess, from being hired for the city was I became an expert in studying words and statutes, because the tax code is 4 million words long, and that's about 5 times longer than the Bible. So I am really good at piecing and parsing sentences in a statute, although it is frustrating to enforce statutes when I'm looking at them and I'm seeing, wow, this really could have been written better. So anyway, medical marijuana. In the city, we have 12 dispensary slots open. 10 are actually open and operating. We have 1 cultivation facility open and operating, and 2 others in process. No production facilities, and 4 laboratories open. So, you know, I guess one of the issues that we've sort of seen on the ground is edibles. Those aren't allowed in the city. I believe that they're allowed in Clark County. So there's a little bit of a difference there. You're probably better at speaking to medical marijuana issues on the business side. But the question that's coming up right now is we're going to be voting on question 2, which is, would legalize marijuana for adults in Nevada, similar to Colorado. You know, I guess the concern at the city level is that perhaps we may not be able to regulate like we've been able to regulate medical marijuana, because question 2 specifically says that the city has the right to zone with regards to marijuana establishments. But that appears to be it if you look at the text of question 2. So for planners, you might want to start thinking about where you want to zone these. I've been to Denver a couple times, and the concern that they told us was that be careful about zoning them into particular areas because you don't want to oversaturate a certain part of town. And so that's a particular challenge that Denver has been facing, is how to make sure that they're evenly distributed throughout the city. Liquor is definitely, something that we see day to day in the licensing division. What I can say in particular is that the license officers do a lot of research to look at special use permits and find out what the conditions on those special use permits are. And they enforce those conditions. Sometimes those conditions don't necessarily track what's on a business license, so that's a challenge. Massage is definitely a problem. We have had licensed establishments recently in the past year closed. We took disciplinary action against them for prostitution-related arrests. So that was an interesting process. And then sexually oriented businesses, I don't know if anybody has been following the news, but Larry's Villa was recently taken before City Council for disciplinary action. And that parlayed into some land use issues because once the tavern license was revoked, then the question came about is when does the land use expire after they had vacated the premises. So do you want to talk more about recreational marijuana?
Sure, if you want to. Actually, I wanted to mention one thing that Suzanne brought up. When I was at the City of Las Vegas, at that time, planning and business licensing were basically two entirely separate autonomous department divisions. That created, from a planner's perspective, sometimes that created a disconnect, and Suzanne highlighted that sometimes you have a condition of approval agreed to at Planning Commission that doesn't make it onto the business license, or the business licensing has to follow and track and enforce. Because I think as planners, a lot of times once that approval happens, you sort of forget about it and you move on, and you don't see what happens on the ground with licensees, particularly tavern licenses that have stricter regulations, SOBs, and massage establishments. So I think it's interesting if you are in a city where and the City of Las Vegas, by the way, now business licensing is within the planning department, which I don't know if that creates its own issues, but I think that's helpful. At least as a planner, I can see why that would be helpful. If you're in a city where that's not the case, just always be aware that there are things going on around you that may affect what you do, or in this case, when the non-conforming use comes back, now you have to figure out what to do with it. So anyway, I think that's an interesting point for you to keep in mind if you don't deal with business licensing on a day-to-day basis.
And with that, I'm Matthew Seibert. I'm from the law firm of Brandon, David Moran. I originally moved to Las Vegas to be involved in gaming licensing and the land use entitlements that go along with that, and in that vein, liquor licensing, and had the luck of getting involved in medical marijuana. So I think we're going to kind of start charting into some deeper, darker waters here. Because everybody has all these questions about medical marijuana, and now, of course, we have question 2, which is, last I checked, pretty evenly divided. I think it's like 47, 46%, with the 47 being in favor. As far as the issues with the medicinal marijuana legislation, I know from my own personal experience, getting all the land use entitlements together, that was a big part of the process. According to the NRS 453A, you were required to have a special use permit in order to operate a facility at the local level to qualify for licensure at the state level. My client, one of my clients, ran into an issue, and this was a complete land use issue where when the state gave their numerical rankings, obviously, as my colleague had said, there were 12 dispensary licenses allotted to the city of Las Vegas. It was based on several factors, but when the state issued their numerical rankings, one of the 12 actually didn't have the prerequisite special use permit, allowing them to operate a medical marijuana facility at their location. Obviously, my client, which was at the time one slot below that number 12, and lucky number 13, had some issues with that. So we went to court and we had to hash out whether or not that was an actual prerequisite. What a mess. We were successful in that litigation in a sense, although it turned out that there was one other person ahead of us. So again, we had to go back and hash all this out again. Now everything's good. I think the problem with the industry now is that these groups are dividing. People are trying to transfer interest out of one, facility or buying interest in another. So that's the issues that I, in my personal experience, am dealing with right now. And then also, everybody talking about what's going to happen in question 2. What's going to involve? How is it going to be implemented? Obviously, my clients and people in the medical marijuana industry are going to have a huge competitive advantage. They're going to be, probably 6 months to a year ahead of everybody else as far as, coming to market, while everybody else is scrambling, trying to figure out what to do. I can't wait for that. It's going to be a lot of fun. As far as, planning issues to talk to, I was kind of at a loss because this is all very new legislation. There's been some litigation. There's been a lot of questions. So I think I'll just take the dive and I'll open it up to questions because I'd like to hear kind of what you guys are seeing in your own jurisdictions and some of them I may be able to address, some of them I can maybe sympathize with and just hold my hands up in the air because a lot of this from my experience has just been kind of, I feel like people are making up regulations as they go along. State comes out with their regulations, gaming comes out with theirs, there's a conflict, everybody has to throw their hands in the air, and they do all their deals, and we start moving forward again from there.
And I think it's pretty unique in this process that you have something that has to move, has so many parts that have to fall into place so quickly. And I think every jurisdiction got something wrong, different things in each jurisdiction. And thankfully, Clark County, they were the sacrificial lamb who went first. And then I think other jurisdictions sort of corrected their processes for that. But planners and folks in business licensing were really in the line of fire here. And there was so much to coordinate because normally in a typical land use, a special use permit, or if you're applying for a permit for a subdivision or you want to build pretty much anything, the state isn't really involved. But here the state is very involved. And this is not their area of expertise. No one's from the state, right? This is not their area of expertise. So I agree with Matt. I submitted a handful of applications, and I think they were, I won't go quite so far to say they were making stuff up as they went along, but they were. Okay, they were. All right, you said it, not me. They were certainly learning as they went, to be a little more politically correct about it. But it will be interesting to see what happens with question 2. And I'll give, I submitted the only jurisdiction I didn't submit applications in was Clark County. And in both Henderson and Las Vegas, there was a cutoff that, it was at 4 o'clock on a Thursday or something. And so I show up in Henderson at 3:59. And thankfully I saw Greg Toth at the front. I'm like, Greg, help. And so you go through the initial process, you go into a back room, there's just boxes everywhere. And I'm like, how are they going to deal with this stuff? I still don't know how they did what they did, but it was certainly a unique process. I don't know that in my lifetime I will ever see something quite like that again. Everybody would complain about how slow we were. Well, there's a reason for that, because it's methodical and we're dotting our I's and crossing our T's. And when that process gets truncated and there's multiple agencies involved, sometimes bad things happen. But Jim, you had a question?
Yeah, if question 2 doesn't survive, will medical marijuana survive, basically?
Absolutely.
Okay. And why is that?
Because it's already enacted. in
Is
state
it
law.
doing well? I mean, is it?
Exceedingly well. I know my clients are, they're making money. They're It is, yeah. It'll move.
Yeah.
There's nothing that's gonna stop it. Everybody can hear me, right, without the microphone? Okay, good. I feel awkward holding that. Okay. Gentlemen,
Is there anything in the law regarding marijuana, the current legislation that be passed or the one that exists for medical, that a community, a county, or city, or anything can deny the location of any such facility within it?
so are you saying completely outright restricted?
Clear outright restriction, yeah, total ban.
Was it Elko County that attempted to do something like that?
That's why I'm interested.
Yeah, I believe there's been attempts made to do that.
There is. The current 453A allows jurisdictions to opt out. Most of the rural counties in Nevada opted out of medical marijuana. And I'm with Washoe County, and I would encourage our southern neighbors. We've already had meetings up north to talk about question 2. Our takeaway from Denver a year ago during their symposium on all things marijuana. And by the way, if you haven't taken a tour of a medical marijuana facility, and if you're in the regulation business, you need to do so to understand and have partnerships with those who own and operate those facilities, because that's the best way to get anything moving forward. And that was one of the 2 lessons out of Denver. Have a partnership with the actual marijuana vendors, those who have an interest in the business. And 2, what happened in Colorado was when their initiative passed, they had 90 days to implement. And they were behind the power curve from day 1. Our concern is we don't currently see an opt-out provision in question 2. And I agree with you. We also see that you're strictly limited to zoning. And also, it appears to be that there's a 2-year, people who currently have medical marijuana dispensaries for 2 years are going to be a leg up on everybody else. Our major concern is that if question 2 passes, the state legislature has to act on it in the 2017 session. Currently, there is no structure in the mechanisms in the state legislature to allow local jurisdictions to be a part of the process to formulate the regulations. And I think from north and south, it behooves all of us to get a seat at the table. There is currently in question 2, again, no funding mechanism within the excise tax or the other taxation for local jurisdictions. That's a problem in 453A, and it's going to be compounded if we allow the state legislatures, if question 2 passes, to cut us out of the equation again, to fund us for the things we have to do to regulate marijuana. So I'm sending that out. Talk to Kevin Schiller, the Washoe County Assistant County Manager, who's leading it for us, to please coordinate on that with our lobbyists to get a seat at the table in the discussions if question 2 passes, because otherwise we're going to be left out to dry again.
Right, and also with regards to question 2, if it does pass, it can't be changed for 3 years because it's a different form of enacting a law. It's a ballot initiative. So I don't know how much the legislature will be able to regulate around it, but it certainly can't change it. And I don't see any opt-out provisions at all. You can look at Colorado's Amendment 64, which allows for adult use of marijuana, and it is completely different from question 2. Colorado's amendment allows for dual licensing by the state and the locality. That's not in place in question 2. It appears that all of the regulation will be with the Department of Taxation. The Department of Taxation does not have any enforcement units. They have one person in the South regulating or responsible for enforcement of the 3-tier system for liquor. So, you know, I agree. There's definitely some gaps there and concerns from the city and county level.
And our take on that, by the way, is that's where we need to be sitting at the table to fill those gaps.
Yeah.
Because the state is totally clueless, and they need to have and I'm honest, right? We call them on an enforcement case where there's people growing marijuana in the backyard, and they say, you can go ahead into our website and see if they have a patient card, because you can do that today, right? Okay, where's your enforcement arm? Because now you're forcing the local law enforcement to figure out whether or not this person's got a patient card today as to whether or not they can grow, and by the way, they're growing outside, which they're not allowed to do, but they don't take any role in it. So that's where we believe it's important to do that coordination to fill the gaps.
Couple of comments. First, thank God I retired early enough to watch the kind that Bob has to take care of. But more importantly, I keep hearing references to Colorado, and I'm assuming that maybe someone will be wise enough to actually ask you for your advice. What I don't hear is any discussion about what Oregon, Washington, or Alaska have done with the same issue. Is it because they haven't progressed far enough to be looked at as potentially different models for local regulation, or are their laws so different from what does question 2 more mirror Colorado than it does Washington, Oregon, and Alaska?
From what I've seen, there's just
Could you use the microphone? I'm sorry, ma'am. My apologies.
There's just been a lot more, I guess, outreach from Colorado to officials in Nevada. So, I've traveled with Senator Farley up to Denver to try to learn from what's going on.